Good evening. Weber State University promotes the exchange of knowledge and ideas through teaching, research, critical evaluation, civil discourse, and debate, and introduces campus communities to diverse viewpoints. The university maintains institutional neutrality and does not endorse any party, ideology, or candidate. The Walker Institute of Politics and Public Service cultivates civic dispositions within the student population and our community by fostering the civic attitudes of political efficacy, civic empathy, civic duty, civic confidence, civic reflection, and an inclination to engage in dialogue across differences. To facilitate that effort, the Walker Institute hosts events to educate our student population as well as our community on civic issues. So, to that purpose, like no one's over here, so are you on this side? For today's Walker Civic Symposium, which we are partnering with Path Forward Utah, we would like to welcome a conversation around faith versus funding. Should religion be allowed in public charter schools? The moderator will be Senator Heidi Baldery, with panelist William C. Duncan, Constitutional Law and Religious Freedom Fellow at the Sutherland Institute, Michael Erickson, partner at Ray Quinney and Nebeker, I apologize, I should have checked before that, I'm sorry. And Royce Van Tassel, Executive Director for Utah Association of Public Charter Schools. We would like to say thank you to Kevin Johnson Media for making this possible on live stream. I'm going to turn it over to the Senator. The show is yours.
Thank you very much. It's a pleasure to be here with each of you tonight. Appreciate your time and attention, and especially our panelists. Really, my job is the least hard, so thank you for agreeing to be here with us this evening. I have just a brief note of each of you, so I'm going to ask you a fun question, and I want you to tell us. So I'm going to just say a little bit, and then I'd like you each to tell me about a favorite teacher. So, first of all, we have William C. Duncan. He's a constitutional law expert, Sutherland Institute fellow, and I'm looking forward to seeing his perspective on legal precedent and religious freedom. And we'll let you tell us about your favorite teacher.
Okay, I have lots of favorite teachers.
Turn on the mic.
I thought I did, is it not? I'm seeing. Maybe
Test.
This one yours. So I think probably my favorite teacher was Mrs. Bailey in the 3rd grade, just because she was so demanding, and it sort of made me a good writer to be in our class.
Wonderful, thank you so much. Okay, Royce, let me just say a little bit about you. Royce Van Tassel is the Executive Director of the Utah Association of Public Charter Schools, and I'm looking forward to hearing about his practical impact on the school administration and policy. And anything else that you might want to say, but we'd love to hear about your favorite teacher.
Picking one is hard, but given the topic today, somehow I think Dr. Ralph Hancock at BYU would be a good choice. Took a number of classes from him, back a couple of them on Church and State, so love Dr. Hancock.
Excellent, thank you. And last but not least, we have Mike Erickson, who is a legal practitioner, and I'm looking forward to hearing your perspective on implications for education. Yes, and I'm looking forward to your perspective on implications for education law, precedent, and legal structure, and anything else that you might have to contribute. And tell us about a favorite teacher.
Well, thank you. I look forward to being with you this evening, and I'll choose a favorite teacher, former member of the Utah Supreme Court, Thomas Lee, is a law student at Brigham Young University, and I think what stands out to me was that even though this was an age when we were beginning to have laptops in school and could be distracted by what we were viewing on those laptops, which has become an epidemic nowadays in the classroom, Professor Lee was so engaging and perhaps so demanding with his teaching that there wasn't any time to be distracted. It required full attention to be able to keep up with his engaging and informative lectures.
Thank you, Mike. Excellent. Well, I think most of you are here today I want to thank, first, again, the Aline Walker Institute of Politics, as well as Path Forward Utah for sponsoring this event tonight. And we're here really to talk about the topic of faith versus funding. Should religion be allowed in public charter schools? And this is a very timely and complex issue. And as most of you may know in this room, right now before the U.S. Supreme Court, they are poised to clarify the constitutional boundaries surrounding religious expression in publicly funded education. And specifically, the case, for those of you who are unaware, that you're welcome to look up, or after we're done this evening, is with the St. Isidore of Seville Catholic School versus Drummond. And basically this is recent. So in 2023, the Oklahoma Statewide Virtual Charter School approved the application of St. Isidore Seville Catholic School, making it the very first publicly funded religious charter school in the entire nation. So the school was backed by the Archdiocese of Oklahoma City and the Diocese of Tulsa, and it was intended to integrate Catholic teachings with state-mandated curricula. The Oklahoma Attorney General Drummond, challenged the approval, saying that it violated both state and federal constitutional provisions. And then in June of 2024, what happened is we had the Oklahoma Supreme Court siding with Drummond. And the ruling stated that charter schools are public entities and must remain non-sectarian. Approving a religious charter school would breach the Establishment Clause of the First Amendment by channeling public funds to religious instruction. And such approval also contravened Oklahoma's constitutional mandate to maintain a system of free public schools free from sectarian control. That was the ruling. So the legal, so they just decided to take it to the Supreme Court, and the legal questions currently before the U.S. Supreme Court are I'm going to just drill it down to two things. First, state action. Do the academic and pedagogical decisions of a privately owned and operated school constitute state action merely because it contracts with the state to provide free education? And two, the free exercise clause, which is, we're going to talk a lot about those two clauses, or I'm not, they are. But the free exercise clause, which does excluding privately run religious schools from a state's charter school program solely due to their religious nature, violate the First Amendment's free exercise clause? Or can a state justify such exclusion by invoking interests that extend beyond the Establishment Clause requirements? So with that, we'll get into the questions, but I know you guys are so excited. Okay. And for those of you wondering what else we're going to talk about tonight, besides public funding, just the implications that this has for some other programs that are currently in the state of Utah, primarily the UFA, or Utah Fits All, which is our school choice program. We're going to touch on school autonomy and religious liberty, accountability and curriculum concerns, and then the policy impacts on Utah charter schools if SCOTUS mandates religious inclusion. So with that, question number one. The Supreme Court has indicated in recent years, and now again, that excluding religious schools from public funding could be unconstitutional. So the question is, what legal precedents or arguments support this shift? And we'll kind of switch around the order, but for now, let's just go to my left, and we'll start with you.
If this mic does, okay, picked up. Okay, so that's a sign I am allowed to speak. Yeah, thank you for first of all for moderating the panel and for raising those good questions. So I think that the cases that are probably most relevant, there's a number of cases. There's probably four that, and I won't give them in great detail, but three of them all deal with this question of public funding. And in each case, a state program was already established to provide benefits typically to all schools. In one instance, in the Trinity Lutheran case, it was a program for recycling tires to make safe playgrounds. The other one involved a program that gave assistance to parents, and they could then use that to go to a private school if that made sense to their family. And then the third case had a very similar facts about again, a scholarship program that went to parents and they could use in private schools. And in all three cases, the state's position in New Mexico, Maine, and Missouri, thank you, Missouri, they said, well, we can't allow any state money to be given to religious school because they're religious. They're excluded from that program. And that if you're interested in sort of the thinking behind that and the history behind that, I'm glad to talk about that maybe more later. But the basic, I think, thing that's worth thinking about is that creates a potential tension. On the one hand, for some people that would make sense. Oh, we don't want public money to go to private religious schools. But on the other hand, if these programs are open to any other person, any other private school or any other entity, why should religious organizations be excluded just because they're religious? That seems to violate the First Amendment. And that's what the court held, that exclusion discriminates against religious schools, and so that's unconstitutional. So St. Isidore's school, or the St. Isidore's, I think it's called the school, in this case is saying we're right in that same stream. This is exactly the same situation. The only reason that the Attorney General wants us to be excluded from the Oklahoma charter school program is because we're a religious university, and that's so much like these other Carson, Trinity Lutheran, and Espinosa. Thank you. I think we know who should have answered this question, but this sort of fits so well with those other cases. So easy answer for us. There's some reasons why that may not apply, but I know that's beyond your question. So that helps. Can I just mention one other case that I think is going to end up being important here? And it's a case from Philadelphia called Fulton versus City of Philadelphia. And this came up a number of times in the oral argument because in that case, the City of Philadelphia contracted with Catholic Charities for placing children in foster care. And the city wanted the the Catholic agency, to endorse a view of marriage that was at odds with the Catholic Church's teachings. And the court said you can't make it a condition of receiving public funding that they violate their religious faith. That's a simplified description. I think that case may also end up being important. At least it came up a number of times in the oral argument where the justices were asking the attorneys questions a few weeks ago. So I would say those are probably the four religious freedom, free exercise cases that would be most significant.
Excellent, thank you. And just for the audience, and by the way, I'm learning right here along with you, but as the chair of the Senate chair of the Public Appropriations Subcommittee, I care a lot about what happens in this case, and it's going to determine how we appropriate our funds. But I will just say the two clauses that we're going to talk about a lot, are the free exercise and then the establishment clause. So just to kind of sum those up in layman's terms, the free exercise clause it's the part in the First Amendment that says you can practice your religion freely, but the government can't stop you from worship unless a strong reason, like protecting public safety, is at bay. Now, the Establishment Clause, it says that the government can't promote or support one religion over another or favor non-religion. It tells the government it must stay neutral. So those are the two clauses you're going to hear a lot about this evening. And, I think the struggle for the Supreme Court is going to be striking that balance because the two are in conflict. And, basically the government needs to let us be free to believe and worship as we choose. And then the government also needs to stay out of it. So they kind of have some tension there. So with that, let's go now to Royce. And would you like me to restate it, or are you good?
I think so. The question that's really being decided in many ways. I mean, there's a lot of legal analysis that goes into this, but in many ways, the question the court is trying to decide is a charter school a public school? That goes to what Bill said about the Fulton analysis, because St. Isidore says we are like the Catholic Charity in Philadelphia. We are just a contractor, and we are providing public education services. And the question, I think, if a charter school is a public school, then the First Amendment applies, and the state can't put its thumb on one side or the other. If, on the other hand, a charter school is just a public contractor, then I suspect the court will say that the free exercise analysis applies. And I'm very clear, 46 states and the federal government, so all of the states that have charter law, and the federal government, which administers literally hundreds of millions of dollars a year in federal charter school money. All of those laws say explicitly that charter schools are part of the public education system. Our state constitution says that, just as the Oklahoma constitution says that. The question, I think, gets challenging, and the reason that I am perhaps more persuaded by the establishment side of this equation goes something like this. We've got some people that have put charter schools together in the back here, and that's a really difficult process. There is no rubric where if you check all these boxes, we're just going to give you a charter. Inevitably, they're going to say, you've done these things, but maybe we do or maybe we don't. You can't come up with that exhaustive list. And so someone's going to have to make a decision. You should check all those boxes, but all those boxes will never be enough. And the question becomes, what happens? Let's say that we decide we're going to approve the Catholic school, but we, for whatever reason, are uncomfortable with the Jewish school or the Protestant school. That, I think, inevitably raises the question, do you have to approve all religious charter schools? Because that's a problem, I think. I don't think we want to just say, yeah, we trust you. Because we're literally, I'm on the board of a charter school down in Moab. Our budget, we're the smallest school in the state, and our budget is $1.3 million. The biggest charter school in the state is, I don't know, $55, $60 million a year. And do you want to just hand that over willy-nilly because they are part of a religion? Clearly, that's not the case. And so how do you manage that question of, oh, we're comfortable with the Mormon charter school, but we're not comfortable with that. And there's just, I think, no way to avoid the inevitable challenge that an authorizer, which is clearly an arm of the state, is going to confront. And so if we put our thumb on that, I can't see how we avoid an establishment clause problem. I'll just leave it there. There's a lot more to talk about, but I'll leave it there.
Thank you, Royce. And we'll turn it now to Mike. And also just, I guess, to kind of add a sub-question to the question, how do you interpret the court's current posture on the issue, and could this create a legal obligation for states to fund religious charters?
Well, I think I pick up with the first question, if that's all right, and talk about that for a second. I agree with much of what here has been shared by Bill and Royce. Bill has given an outline of the free exercise cases and describing why for many people this case seems to follow along that trajectory, that if you have an available program that is something that is neutral and that is available to anyone in the public to be able to come and to apply for, from this point of view, it makes little sense to exclude an organization simply because they are religious. The crux of where this becomes a more difficult issue to decide from the three cases that Bill was describing is what Royce is pointing out from the establishment perspective. And so we have this real intersection between the Establishment Clause and the Free Exercise Clause, because unlike a case, for example, where the Supreme Court is deciding whether or not a neutrally applicable program for a school to receive some assistance in a program for their playground with wood chips and pavement, et cetera, like that, it's getting right at the heart of the education and a religious education and tackling head on whether or not a neutrally applicable program that is available to everyone to apply for can actually fund religious education as part of the education. If it meets all of the other requirements of the state that allows for there's a requirement in Oklahoma in the charter school program, you got to teach reading, writing, and arithmetic. It's got to be to a certain standard. But when that standard is met, if you want a flavor that is beyond that, whether it's a Spanish immersion or whether or not it's a focus on Native American history or whether or not it has a more industrial focus and work, or if that preference is a religious focus, then that is something that ought to be freely available to any organization. That's the crux, is once you hit that religion being in there, are you then making an establishment of religion, the concerns that Royce was explaining? I think it's helpful for me, and I hope this will be helpful to everyone else, to write in a little bit more background, to go back a little bit of history, because this case intersects with certain trends in education in the United States and with the view of the Establishment Clause that all come together in a really intersections. I'm hoping Royce is agreeing with me here and seeing where I'm headed with this, because the ways in which this is all going to intersect in this case is really remarkable. And I'm going to describe four eras of history here with relationship to schools and religion and the government. The first era, you can go back all the way to the founding. This is it's really fascinating case because you don't often see this kind of historical context to a Supreme Court case. But the petitioner's brief goes back to the very founding and talking about the nature of what's happening when the Constitution is being decided. An original interpretation of the Constitution is something that has become very significant to the Supreme Court. Even Justice Kagan describing we're all originalists now, we're all textualists, or I shouldn't say originalists, but all textualists, and originalism is a type of that, and looking at the meaning of the Constitution. And so when the meaning of the Constitution and the Free Exercise and the Establishment Clause, what's going on in the founding with respect to religion in schools? And the reality is that many, if not most, schools in America at the founding are religious schools, and many of them, if not most of them, are also receiving funding from their state governments. Now, in this early period of American history, the big issue was disestablishing the church, not from education, but from government. And so most of the states that come into the Union together, there is a strong, in the beginning, there's a strong establishment of religion. In Massachusetts, among the descendants of Puritans and Separatists and Pilgrims, it is the Congregational Churches of Massachusetts. In Virginia, with its Anglican roots back to England, it's the Anglican Church. And so there are movements, the first 40, 50 years of history of the United States, and this important separation between not establishing religion on the state level. The First Amendment prevented it at the federal level, but at the state level, at this point, the Constitution does not apply to the states. That doesn't happen until the Civil War. And at the state level, many of these states were deciding we are going to take steps to disentangle our governments with supporting a particular religion. At the same time, interestingly, however, though, all of the schools, for the most part, are religious schools. Most of are well-known universities in the East, from Harvard to Yale. They're all established as religious schools, and that goes down to primary education as well. And so for the first, from the briefs describe it this way, the litigants are describing, from the Bill of Rights to the Civil War, you have this strong era of religion and schooling are connected together. What begins to happen in the middle of the 19th century is a common public school movement where public schools are now being supported and controlled. It's no longer just funding to private organizations that are teaching. It's the state is going to teach public schools, is going to have a curriculum, and there's a common denominator of Protestantism in those schools, the predominant religious faith in the United States. This is Horace Mann and his common school movement. And at the same time, you have immigration from countries that are more Catholic. So whether it's Irish immigrants or Italian immigrants, there starts to be a larger influx that the United States has seen before in Catholic schools. And there is concern over there being money spent on these Catholic schools. And so these amendments come up. We refer to them generally as Blaine amendments, where there is to be no funding for sectarian schools. And so schools are channeled into the public space that is largely Protestant, and there are requirements to keep out any kind of sectarian schools, which in the decisions that Bill referenced earlier and in the background of the decisions are described as, look, that's just code word, sectarian is code word for Catholic. Okay? And so you have this kind of arguably, from one perspective, an anti-Catholic bias in school history with a predominantly kind of baseline Protestantism. The next period really develops in the middle of the 20th century. And this is for, I grew up in the 70s, 1980s. And this period is the secularization of education. So there's no longer a base kind of Protestantism of maybe reading from the Bible and praying in school. Now it is everything religion is out of schools. Some of that may have been a concern for the kind of maybe argue of anti-Catholic or anti-Jewish bias among Protestant schools, but it goes even beyond that, so that even Jewish rabbis are not allowed to pray, and there's no prayer or no religious discussion whatsoever. Myself, growing up in that time period, was like just taboo. You don't ever touch, public school doesn't ever touch religion. But that is just a period of time in our history, and different from other periods of time. And now we're in arguably a new era where there is, because of the makeup of the Supreme Court, there is an openness towards there being the cases that Bill mentioned. And this case potentially could begin a very transformative time period in America where you now have the United States the government not choosing a particular religion, but being willing to fund religious education of multiple religions, whichever religious schools apply for and are part of the differences and the variety that's being offered in the charter school program because of the movement to school choice. It was a long-winded answer, and thanks everybody for taking patience there, but I hoped that the history would be helpful for all of us to.
I loved it. So thank you for that historical lesson. That was awesome. It's interesting, the cultural shift that you mentioned more recently. So one of the cases that y'all mentioned earlier was the Trinity Lutheran versus Comer case, which was the Missouri case about whether to fund the playground materials. That case was in 2017. A more recent case in 2020 is the Espinosa versus Montana. And I think that was briefly mentioned, but I just want to give some context. So from where we came in 2017, not we, editorial we, the Supreme Court case in 2017, all the way to 2020, which is when the Espinosa versus Montana case is, Montana had a program giving tax credits to people who donated to private school scholarships, but the state said that those scholarships couldn't go to religious schools. The Supreme Court said that's not allowed. If a state gives money for private schools, it can't exclude religious ones because that's discrimination. Under which clause? the free exercise clause. So if the government helps private schools, it can't leave out religious ones just because they're religious. So again, it's interesting, as we see it shifting, and now we're here in 2025, 2017 to 2020, 2025. I would love to know how you think this case is going to end. But let's save that for the end. That we'll finish with that. So the next question I have is, and we'll start backwards. So I know you just spoke, but you get to again. The next question: should a religious school that receives state funding, and we touched on this a little bit, be classified as a public charter school? And what are the legal? And maybe I think we answered that. But what are the legal? Let's do this. What are the legal and philosophical implications of such a designation?
Well, I'm going to try to be brief this time around to give Royce and Bill time to comment on this more. I think I'll just comment here and maybe skipping over the philosophical implications, just the legal implications and a distinction that is made in essence between state and public. And this gets at the heart of the first issue that the court is going to have to decide is a religious charter school in Oklahoma's system, is this a state actor? Because everybody agrees that if a charter school is a state actor, then it would be an establishment of religion for that state actor to have a religious influence. And so, but where it turns here is really a distinction with the word, maybe state and public. Now, sometimes we hear public in that, we think of state, but the distinction that's being made here by the petitioners, by St. Isidore's School and the Oklahoma Charter School Board that approved this is saying, well, look, just because the charter school is public, what public means in this case is open to everybody and funded by public money. That is different from a public school, which I'll refer to as a state school, where the teachers are under direct oversight of the organs of the state, right? They are paid by the state. The people supervising them, the principals, are paid by the state. Above the principals is the boards and et cetera. There's direct lines of the state making every decision about what is happening in that curriculum and how it's being taught and who's teaching it, et cetera. It's all state controlled. And so the argument on the other side of this for the Oklahoma Charter Board and for the St. Isidore's, the Catholic school applicant, is to say, look, we are all private controlled. It's a private board. It is private decisions that we are making. There's just two things that are essentially public about it. There's a third that I'm going to say they're not necessarily focusing on. But first, that open to the public, so everybody's welcome to apply for, come to our school. Number two, it's public funding that per pupil that's coming in. The part that gets difficult for them is the oversight, because there is oversight of the school, and that's where the real tension is between whether or not this is just public, is open to the public, or whether or not it is state. And it's the level of that oversight, where is the, does it look more like a state school, a state public school, or does it look like a private school that just happens to be receiving public funding? And the different states can do that differently in how they set up their charter school system. So this decision isn't necessarily going to apply across the country the same way, because all 40, is it 46 or 47? 46. All 46 of the states have differences in how they set up. There's similarities as well, but the differences could mean that in some states, religious charter schools are going to pass muster under the Establishment and Free Exercise Clause. In other states, those charter schools are going to be deemed as state actors and state schools where it doesn't pass muster in the Establishment Clause and therefore are not allowed.
Thank you, Royce.
So I think you make a very important point. A lot of the commentary sort of sees this as a black and white issue, and I'm very confident that what we're going to get is an opinion, almost certainly written by Chief Justice Roberts, and everybody's going to go and look at that and hold it up. This is a template that says, how does this apply in 46 states, and there's, like Guam and Puerto Rico and a couple other territories, DC. So it is not 100% clear. But the question about are they a public school or are they a state actor? One of the tests that the court has set up asks these two questions. Is it state created? And does the state have the ability to close them unilaterally? And that goes to, in some ways, I mean, it's interesting to read the briefs because it looks like a factual question, but it's less clear. So in Utah, as in every other state, you have to be an independent 501c3 nonprofit. And you can then be approved as a charter school. And one of the questions that this case is probably going to turn on is St. Isidore Inc., the nonprofit, identical to the school that was formed when the charter was created? Because if they are identical, then it is a state actor. And frankly, I've been the head of the Charter School Association here in Utah for 10 or 11 years. We've closed a number of charter schools in Utah, all of them while I've been the head of the association. It's never fun, but frankly, when it needs to happen, it needs to happen. And it would be awkward at best to say, I'm going to go and close the Catholic school. That would be that would just feel weird. We don't normally give the state the ability to close an arm of a religious institution. I mean, here in Utah, we have some really sad history with the way that played out 150 years ago. And so it's awkward. And Utah is in a very different place, frankly, than other states. But if the St. Isidore Inc., that nonprofit, is separate from the school, then you approach it very differently. And I would look at this and say the nonprofit that that the Catholics formed is the predecessor to, but not the charter school. The charter school was formed when I gave you a charter. I blessed you and said, you can take these dollars. And now I can also close you, the school. I can't eliminate the nonprofit, but I can close the school, which didn't exist until I, the authorizer, as we call them in Utah, sponsors in other states. But until the authorizer or the sponsor says, yes, you have a contract to do this, the school itself doesn't exist. And that is why, again, another reason why I think that the Establishment Clause ends up governing this as opposed to the free exercise. Mind you, I want to be clear, no one should imagine that I'm opposed to religious education. I celebrated the day the Zellman case was handed down back in 2003, and no one else knows, these two know what the Zellman case is, maybe someone else does. But that was the case that in many ways is the basis for the cases that Bill talked about, that says, yes, those public dollars can flow to religious education precisely because parents chose. And those parents as intervening actors, as the ones that are actually directing where those dollars go, we don't get to tell them. That clearly is a free exercise problem. But this case, we don't have an intervening actor, as I talked about before.
Thank you, Bill.
Yeah, I'd like to maybe talk about your second question about implications, because I think that could be really significant. What I hope the court will do, maybe that's kind of what the theme I'll give here is, first, as it relates to the question of a recipient of public funding being a state actor, I hope they will reject that idea. I think that's a bad mistake to go down that road. Partially because so many private entities are already receiving some kind public support. In the case, they focus on the idea of public defenders. I have a brother-in-law who's a public defender, so that resonated with me. Just because you get money to perform an important service for the state doesn't mean that you automatically are the state. So I think they should veer away from that. But I think the other thing that would be really valuable if the court would do it, and I don't know whether that's likely. I mean, given how fact-specific this case could be, I suspect it'll be a narrow decision. But if they wanted to do this, they could clear up a lot of confusion that I think the U.S. Supreme Court has created in this field. By treating the Establishment Clause and the Free Exercise Clause as being in tension with each other. Because I think if you think about it, we have in our First Amendment, we have two religion clauses, free exercise and establishment. And for whatever reason, I have a lot of thoughts about why this came to be. The free exercise clause is pretty well understood as protecting religious freedom, right? The ability of a person to practice their belief without being burdened by the state. But for whatever reason, there's a belief that the Establishment Clause is kind of like an anti-free exercise. It's like, it's sort of a way of keeping free exercise from going too far. That seems unlikely as an explanation of having both clauses in the First Amendment. They both, I think, should be understood as being protections of religious freedom, but coming from different directions. The way that I took this from Michael Paulson, you think about free exercise as being a proscription, keeping the state from doing certain things to religious people, and the Establishment Clause being prescriptive, saying the state cannot favor one religion over another or force people to support a religious belief that they are uncomfortable with because of their own beliefs, for the reasons that Mike described earlier. So if you put those together and you think, well, there's got to be, as I think there's got to be some way that those two parts of the Constitution that they have to mesh somehow. The Supreme Court could do a really great thing in kind of describing how they could both point in the same direction of protecting religious freedom, which I think is the real core constitutional value that both parts of that amendment are intended to provide. So with that in mind, the Supreme Court, I think, should sort of be more serious about what does the Establishment Clause mean and where did it come from. Initially, and this is contested, but I think it really is a jurisdictional thing. It has to do with which branch of government gets to decide if there's any kind of like established religion. And clearly, the First Amendment said the federal government is not allowed to do that. But for a number of years, for decades after the First Amendment is enacted, the states continue to have establishments. Even though that it would apparently be at odds with our current understanding of the Establishment Clause. And I think so. Recognizing that it's a question of authority, are states allowed to support religion, or are they prohibited from doing that? If we say that states have some role in maybe treating the religions a little differently than the federal government does, then I think we can begin to mesh those two clauses together. Now, I don't think it's the case, this may be a very personal belief, but I don't think it's the case that the 14th Amendment changes the Establishment Clause into a personal right for people who are offended at religion to then challenge any kind of like public endorsement, even very mild endorsements of religion, in federal court. I don't think that was the intention of anybody at the time the 14th Amendment was ratified. So I think if we take those kinds of, I think, straw men off the table, then we can say, okay, if a state has a prohibition on public funding, let's figure out if that's what's happening, rather than saying, well, gosh, if we're too solicitous of religion, then we might go too far, and the Supreme Court has to rein it back in by I think, a crabbed reading of the Establishment Clause, an unfair reading of the Establishment Clause. So I hope the court will kind of point out those things can be consistent with one another and allow for quite a bit of freedom for people to act on their religious beliefs, and to have public support as long as it, as long as it doesn't sort of violate specific state requirements against establishment. Now I know that begs the question, does this particular do that? And we'll get back, I guess you said, to that later. But if that's, I hope that's a helpful way of maybe describing some things I think it would be good for the court to address.
Thank you for those good points. That leads me to our next question, which is going to be about state autonomy. And, the question is, and we'll go back to you first and then Royce, and then Royce, you'll eventually be first next. But anyhow, so it's about state autonomy. We know each of the states are different, which is the beauty of federalism and allowing the states to lead and to basically be learning laboratories and, to experiment. This is the beauty, and the federal government derives its power from the states. So with state autonomy, the question will be, but before I get into it, should states have the flexibility to define their own policies on funding religious charter schools, or does a uniform federal standard better protect the separation of church and state? And so this is a preference, or maybe it's a policy thing. If you want to defend it that way, your answer that way. So just be thinking about that. You'll be nice. But before I do that, I just want to bring up another case, because we talked about the 2017 case. We talked about one in 2020. So I want to jump ahead to 2022. I think it's interesting to watch where we've come from 2017 to 2020 to 2022. And it was touched on briefly, but it was a case in Maine. I know you mentioned the state. But the case in Maine is the Carson versus Macon in 2022. So in Maine, some rural towns didn't have public high schools. And so the state offered to pay tuition for students to attend private schools instead, but only if the only if the school was non-religious. And there were two families that wanted to use that tuition money to send their kids to religious private schools, but the state said no. And the Supreme Court said in a 6-3 ruling that Maine's rule was unconstitutional. So it said if the state is offering money for private education, it can't exclude schools just because they teach religion. And again, that was a violation of the free exercise clause of the First Amendment, basically discrimination against religion. So if the government is helping pay for private school, it can't say yes to secular schools, but no to religious ones. Once the state offers a benefit, it has to treat religious and non-religious options the same. So state autonomy, we're going back to you, Bill. And should states have the flexibility to define their own policies on funding religious charter schools, or does a uniform federal standard better protect the separation of church and state?
We're sort of trained as lawyers to answer the question we want to answer. So I may judge step a little bit.
Politicians too.
Yeah. I think one thing I wanted to pick up on a comment that you made about discrimination, because that's an important way of thinking about how the establishment of free exercise clauses can be compatible with each other, is to think that they're both intended to prevent discrimination against religious faith. Obviously, if we say that what someone does and as they act on their beliefs is unconstitutional, that's clearly discrimination. Or is prohibited, that's discrimination. But if we say that one particular church is the favorite church of the state, that also is discrimination. So I think that as long as that's the sort of the baseline, that's a fair reading, I think, of the Establishment Clause, and that would be a way to constrain the states from. I think it is appropriate to tell the states they can't have a religious create certain religious views and as being appropriate and some are not. Or some churches are deserving of support while others are not, as Royce phrased that possibility. It's something we want to avoid. Having said that, the phrase the separation of church and state is part of the reason for the confusion, because it makes it sound like that if the state and religion interact in any way, that there's something wrong constitutionally. But of course, that phrase is more recent than the initial Establishment Clause. It came from Thomas Jefferson, and it's arguably what he meant by that. But it's not part of the Constitution. And so the key thing we want to think about is not whether government and religious practice or religious beliefs are being kept separate enough. What we want to think, I think, is there some endorsement of one religion over other religions, or religion over non-religion, or non-religion over religion? And as long as those things are appropriately, as long as those possibilities are screened out, then I think states absolutely should be free to have a large range of responses to religion. If they want to contract with religious organizations to provide social services, I think that's very appropriate, and we see that happening in many states, and I think that's positive. Now, having said that, there may be lots of good reasons, and if someone were to come to me from a religious group, I don't know why they would, but if they were and said, should we do one of these contracts, I might say, well, I'm not sure that's a great idea, because of course when you do that, you have to take on some risk, right? I mean, the state may say, well, gosh, as a condition of this funding, we're going to ask this and this of you, which they may not want to do. And that may be part of what the wise part of what Thomas Jefferson was saying in Separation of Church and State is, let's keep the state away from the churches, try to keep the state from dictating to churches what they do. But to just create a blanket exclusion of churches and religious organizations and people of faith from things they would otherwise be able to do if they weren't acting as a religious organization or people of faith, that part I think is wrong, and that's where I think the state should have the ability to act a little bit differently than the federal government.
Thank you, and I like that you brought up the element of risk, and I think again that's one of the things that is so unique about each of the independent states is that, as the learning laboratories even mentioned, most of us know that freedom is messy. It's much easier if people just all get in line and do the same thing. But with freedom comes risk, and meaning that people might go awry. So I appreciate you bringing up that point. All right, and you're next, Royce.
I think the Carson case is really important on this point. Chief Justice Roberts writes the majority opinion there, and in that case, he very explicitly says that Maine has the option to set up a completely secular public education system. And at least some of those that are participating in the briefs, that wrote amicus briefs, and again, I don't know how Chief Justice Roberts is going to draft his opinion, but one of the risks that we face is that he says, nope, everybody's got to adopt the same posture there. And if that happens, I know with 100% certainty that what we will see is a number of states that have just said, okay, if we have to permit, if we have charter schools, then, and we have to permit religious charter schools, we're just not going to allow charter schools, period, full stop. And you know, that would be a travesty. There are people that would want that. Most of them work for the NEA. But that's the risk that we face, because we do want to have schools or states as laboratories of innovation. And it shouldn't surprise us that Utah's charter landscape can and should look different than Massachusetts. Doesn't mean that Massachusetts is better or worse. But I worry that in enacting potentially a rule that says if you have a charter law, you have to allow a religious applicant, that we may diminish the options that are available to Utah's families, well, not Utah's, we're not going to do that, but around the country, that's a real risk.
Thank you. Go ahead, Mike.
I think in going back to the original question, it seemed to put these to a federal I think it was phrased as separation of church and state versus individual states in our federalist system, and choosing between. And I think how I'd like to respond to this is by endorsing both of those as unique to our American system. While I agree with the way the bill phrased it, going back to the original language of the First Amendment as an establishment, not separation of church and state is a little bit loaded in how that can be described, but to go back to the First Amendment establishment of religion and not having establishment of religion as our First Amendment, along with the Free Exercise Clause, that is the federal oversight in the sense of what happens now incorporated against the states. That provides that protection, and it is unique in the United States. Our anti-establishment history, while in a sense being against, it's been misinterpreted in recent decades as sort of against religion, but its original purpose is to foster religion. And it is what makes the United States distinct and unique. It is why the United States remains the most, among the large democracies in the world, among the large vibrant democracies, the United States remains one of, if not the most religious of those democracies. And part of the reason for that is because there has never been this reaction to established religions that has deadened the faith of citizens by being compelled to religious worship. And so our Establishment Clause has been vital, even though it has been in recent decades taken to an extreme that has, in some respects, has driven out religion from the public square. In its original meaning and understanding, which it seems that the Supreme Court is now in favor of, is a playing field for religion to prosper. And that, in combination with our federalist system, is powerful. I teach as an adjunct professor at UVU, and when we go through the principles of the Constitution, when I talk about federalism, when our class discusses federalism, it is there are many countries that have separation of powers. There are many countries with rule of law. The United States may be exemplary in those ways of its separation of powers and its rule of law. I certainly feel so. But the one way in which the United States is absolutely distinct from any other democracy in the world is in our federalist system, the laboratories of democracy that Senator Marley described. Nobody is more involved in government than Americans. There's nowhere in the world where you've got this 50 legislatures and 50 governors and then a president and each of those states, a lot of them, I think it's maybe Nebraska is the only one's unicameral. You've got a Senate and a House in each one of those states. You've got towns with their town councils. There's nowhere that has so much government and so much experimentation. And those united together create what has been traditionally and will continue to be, hopefully, a vibrant religious community in the United States. Our federalist system and the cases that we're discussing here are proof of that. From Maine and Montana and Missouri. Those are the cases that are coming to the Supreme Court because of these different experimentations by state level that are creating the conditions for us to have a vibrant discussion of the Establishment Clause and the Free Exercise Clause.
Wonderful, thank you. So we have 15 minutes before it's 8 o'clock, and we have 15 minutes left of our panel discussion. I'd like to ask 3 questions. So we haven't timed the other ones. I'm going to give you each 90 seconds, and we'll have my timer will alert you when your time is up. And so I'd like to try to get to these last 3 questions, and then we'll have 15 minutes of questions and answers, questions from the audience and answers from the panel. And so we're changing the format up a little bit, but there are 3 questions, and just so you can be thinking ahead, I'm going to talk about first community impact, then slippery slope, and then the last one would be, the court rules in favor of requiring states to fund religious charter schools, basically the question I said earlier. So let's start, and we'll go Royce, then Mike, then Bill on this one, community impact. Here's the question, Royce. And I'll start the timer once I've asked the question. Could religious charter schools strengthen community values by aligning education with local beliefs, or might they exclude students and families who don't share that same faith?
The short answer, the 5-second answer is yes, to both. I can see both as possibilities depending on where you live, and what your religious perspective is. It is awkward. I can speak from my own family. It is awkward to be in Utah and not feel, especially in Utah County. I live in Utah County. I love Utah County. But it is awkward to live in Utah County, to live in Eagle Mountain and not be LDS, because all of the events are, we do everything together. We're LDS. And I can also see the opportunity, and I see this over at American Heritage, to enhance that religious fervor, and the fact that we have a Jewish school in both Salt Lake City and up in Park City, and we have Catholic schools up and down. So I think the risk is honestly yes.
Thank you for your candor, and I appreciate your vulnerability. That was excellent timing, by the way. Okay, and we'll turn the question now to Mike.
I also really appreciate Royce's answer and agree on both parts as well. It much will depend about how state boards implement, if this becomes law, the option for religious charter schools. And there's no question across this nation, in the different communities and religious values, that there is the opportunity for a more reflective a government, an educational system that reflects local values and local religious faith. At the same time, if not managed carefully, it could very easily become exclusive. Royce's point, doesn't take much imagination in our state with a predominant faith, of which I am a member, where if all of a sudden you have a number of charter schools that reflect that percentage of faith, that can start to feel like an establishment of religion. And so there does have to be some care taken, and there may be additional court decisions. The justices during the oral arguments were discussing this and pointing out cases when, well, that could be a problem for establishment of religion. If there's not a public school option and it's only charter schools, and there are many of those charter schools that are religious, well, that could be a problem. If the St. Isidore's Catholic School does not only allows Catholic students, that could be an establishment of religion. The facts of the case are that by its agreement with the Oklahoma contract, it allows all students to come, but if it were to be different, that could be an establishment problem. So it will depend on how it's implemented, but both options are possible.
Thank you, and we'll finish off this question with Bill.
And I'll agree, and then add an additional point that if the Supreme Court allows religious charter schools, it will be important for the states to watch that the states don't try and exclude some schools because of their religion. That was a disturbing element of this case, is that the Attorney General Drummond has said negative, what if we have Jewish schools, or I think it was Muslim schools was the concern he had, and there's no place for that, I think, in our culture. We can't allow for some schools to be, or some religions to be favored and others not, and we can't use that sort of bigotry against unfamiliar religions to be a reason for us to exclude them from whatever programs we have. So.
Thank you. Great.
I think I evened our time out.
Yeah, you did wonderful. So the next question, we've got two more. So we'll go Mike, Bill, Royce. And this is, I guess I call it the slippery slope question. Would approving public funding for religious charter schools open the door to broader government support for religious institutions? Or is this a narrow issue confined to educational choice? We'll start with Mike.
it would be a sea change in education to have the potential for religious charter schools just from background of growing up with a secular system that predominated in my schooling. I think the potential for there to be religious charter schools is a sea change, and it brings up some of the difficult issues that have been raised. Bill's pointing out just recently the concern specter that's been raised and using some less popular religions as a kind of boogeyman to threaten that if this is the case, we're going to have Muslim schools teaching Sharia law. And from a certain perspective, that's going to inflame certain passions as kind of a scare. From another perspective, and thinking about Muslim communities and the opportunity there for there to be diversity in school choice that reflects certain values on an equal playing field with other options, that's going to be something for certain communities that are going to be remarkable to have that kind of opportunity for them. Now then the difficulty with this becomes the level of involvement, because we can imagine, this was the point that Royce was getting to earlier. So when you have a general educational requirement, okay, you're teaching reading, writing, arithmetic, and you're evaluating that, and it happens to be that then there is some religious teaching in addition to that, kind of flavor, for so to speak, as opposed to this language or this emphasis, then that's just a diversity. But when there becomes sort of an evaluation of that religion, then that becomes a point that becomes, of course, a government entanglement or entwinement with religion, and that will require, if the court were to allow, in general, these religious charter schools, there will undoubtedly be further cases dealing with those issues of denying certain schools that are religious and wondering, well, what was the reason for denying it? Is it because they're not teaching reading, writing, or arithmetic, or is it because you didn't like their religious content?
Thank you. And we'll turn it now to Bill.
I think that was a great and helpful answer, and I think that's right. I think that I'm optimistic though about the Supreme Court's ability to. I think they've done a great job in religious freedom cases and adding some clarity to an issue that for the last couple of decades has been pretty messy. And so I think the court can make some important distinctions. I think this may be going to the later question about how this will end up, but I think it really will be important who controls the school. I think that will be really a key question. And if the court's careful about making distinctions, for instance, it could be appropriate to say, well, look, as long as the parents are the ones making the decision about where the money goes, that kind of thing, those are good rules that I think make sense and can avoid a lot of these problems. So I'm optimistic because I think the U.S. Supreme Court is, this is one area where they think they've done a really good job on the First Amendment to protect religious freedom.
Wonderful. Thank you, gentlemen. Okay, our last question.
I think Royce.
Oh, I'm sorry. Oh, my goodness. Yes, Royce. Slippery slope, yes or no?
Honestly, I really don't have anything to say that hasn't already been said. The possibility exists, but this court is pretty temperate.
Thank you. We maybe can get some bonus time on the last question there. Okay, some room there. I appreciate it, gentlemen. And the last question before our 15-minute Q&A is how eventually, when this case is decided, which way do you think it will go? And the order for the last question will be Bill, Royce, Mike. So, Bill.
If I didn't have scruples against gambling, I would at least not do it because I have such bad track record of guessing things that happen in the future. So I don't know. I'm not quite sure. I think I think all of us probably agree that the most likely opinion writer for this case will be Chief Justice Roberts. So, and I think he'll be the important factor. I think the opinion will be quite narrow and focus on very specific factors that are unique to Oklahoma's situation. Probably, my opinion is that it would probably relate to who controls the school, whether there's enough state control to essentially make it a state school rather than which I know is so I suspect, my guess would be that the court will say that this particular approval of the religious charter school goes too far. That's my guess. I don't know that that's the right. I don't think that's the right decision, but I think that's probably what will happen. Just for all the reasons that have been talked about.
Thank you. Appreciate your answer. Okay. Let's see. And next is Royce.
I think, for those of you who aren't familiar with the nuances here, Justice Amy Coney Barrett recused from that, which means that there are 8. And I think the most likely outcome will be a 4-4 ruling, which means a very short opinion, maybe even one sentence. And it says that the issue will come back another day when Amy Coney Barrett's best friend isn't deeply enmeshed as one of the litigants. I have heard some people, I've heard all kinds of opinions. I heard one person, we were joking about this before, who thought that it would be 6-2, with the 2 being Thomas and Alito losing. I think that extraordinarily unlikely. But I think everything from 6-2 that way to 5-3 in favor, all of those are very realistic possibilities. But I think by far the most likely is 4-4 they split, and this will get litigated again in 3 to 5 years.
I like your predictions. Those are kind of fun. Okay, and last but not least.
I might add might respond just a little bit differently by this way. I think there is a majority of the court. There would be 5 justices this way and a 6th with Justice Barrett, who have a different vision of the Establishment Clause than what has been for the last 40, 50 years. That do not view the Establishment Clause as you cannot ever fund religion. There was an interesting dialogue with Justice Sotomayor about this, who was trying to get at what she called the essence of the Establishment Clause and saying it in that particular way. You can't fund, you can't support religion. And I think that 6 justices in the Supreme Court disagree with Justice Sotomayor's vision of the Establishment Clause and view it as not favoring or tipping the scales, that it doesn't mean that it can't be supported in neutral and open ways. And so I think there's a majority of the Supreme Court for that. I think there's a majority of the Supreme Court, probably all of the Supreme Court, that agrees that certain ways in which charter schools could be and would be set up for religious charter schools would be an establishment of religion. Ways in which there is clearly not options, where it feels like there's a favoritism that either is proved or disproved, or just kind of sensed behind it, or there is just the dynamics where it looks like what's happening for students is that they are not able to choose, and that they're experiencing a coercion that would be that way. In this particular case, I do not know how I think it will be decided by the Supreme Court, because I have given up on trying to predict Chief Justice John Roberts and how he views it. I think I disagree with Bill on one point. I think the issue will not come down to state actor. I think they will find it's not a state actor for some of the ramifications that we haven't talked about that go the other way. I think the issue for Chief Justice Roberts will be the entanglement and whether or not the kinds of issues we were getting at with, okay, so you're deciding a school and the majoritarian religions look fine, and that just looks like flavors among language or vocational or these interests, etc. But if you're having to decide for religions that are not going to be as immediately recognizable or tolerated, then there is a difficulty with that, and I think that's where his mind is going to be on this issue. and maybe just to, to pick something, I'll pick the other way and say 5-3 is going to resolve that is what's going to happen another day, and he's going to join with the other 4 conservative justices and find that this is in line with the Trinity cases.
Thank you, gentlemen. Okay, so I'm going to propose to the panel how you'd like to handle this last 15-minute segment. We can each give a brief 1-minute response or less and have everyone answer the question, or whoever feels strongly about it can answer the question. Do you have a preference, gentlemen? Audience, go
I
ahead.
think we can just take it as it comes here.
Take it as it comes? Okay, do you have yes? Okay, so, okay, just a second. One moment, we're gonna change it to 1-minute answers so we can get more questions. So,
Yeah, do you want me to just yell it?
No, can you also repeat your question, please?
yes, I will repeat the question. Let me,